And you know, some lawyers also have a very valid argument on this. They say even the NJC shouldn't have been consulted, even that particular resolution shouldn't have been reached, because they are trying to consider Section 42(1) of the 1999 Constitution, which says, I'll give the quote here, a citizen of Nigeria of a particular community, ethnic group, place of origin, sex, religion, or political opinion shall not by reason only that he is such a person, A, be subjected either expressly by or the practical application of any law. And it went further and further, talked about sex, origin, and all that. So it looks like the Constitution already as it stands has actually dealt with this case.
I said it, as I said from when we started. You see, the fact is that mistakes have been made, and good enough has been corrected. And that's one good thing about the judiciary. The judiciary tries to listen to itself, and the NJC is filled with a lot of respectable retired justices, current justices, attorney generals, and senior lawyers. So you see, that's why I sometimes tend to say the executive, when the NJC comes up with decisions, sometimes the executive should look at it seriously, because a lot of thinking, a lot of age at the bar and the bench have gone into such decisions. I'm sure if the CJN was a politician, he would have said, go to hell. I've taken my decision, that's it. But they've been able to convince the CJN to see otherwise. And the CJN has agreed. No. That is it. I will not, mistakes have been made, unfortunately. Unfortunately, yes. And the woman could sue for enforcement of her fundamental rights. The Honorable, my Lord, could sue. But, you know, the judges also are stopped from contesting matters. They are always not heard. They only seen and not heard. Now, so this is another
This matter appears to have been solved, but tomorrow there might be something else like this. What about the situation where some judges or to attain a certain position in a state, you use your state of origin? I mean, some women could be a judge based on where they come from here. But to move up to the federal level, they now choose to use the state of origin, the state they married into. Wouldn't that cause a problem, especially with the federal character issue?
Yeah, we've discussed this here before. We've known how some judges move their state of origin, especially the female judges, from state of birth to state of marriage.
Because of the
desire to move up here. I mean, the story of where somebody is from a particular geopolitical zone, and the husband is from the other geopolitical zone, juggles between here and there for the purpose. But those are unethical, you understand, because they try to defeat the system. But the fact is that the National Assembly should also look at this issue of national character. It's like what you have in the United States, where you make special provisions for people of color, people that are born in particular areas, to help them to grow and meet up with the system. This national character law has been there for over 30 years. It's getting to almost 40 years that it has been there. What reviews have we done? What has been achieved? We should be able to analyze and look at it. Look, this was the benchmark we wanted to achieve. This is what we have achieved. Is it still relevant? Is it still relevant? Because there was a time the NBA came out shooting that the Northwest had too many justices from the Northwest in the Court of Appeal, and more than the whole of the Southwest. South and Southeast put together. So, are these things? Because of that, some judges were not elevated to the Court of Appeal from the Northwest. So, if the people, these persons in the National Assembly are really working, they should now come and say, look at this law. Is this law still relevant to us? Are we using it to feather some nest?
You know, it brings to mind what you just said about the composition of the NJC. In the light of all of that, knowing full well that so much go into their decisions, should the CJN, as a primacy inter pares, possess the powers that she already does by overriding the decision of the NJC?
You see, let's be practical in this matter. The CJN is a herd of both the NJC and the judiciary. The office of the CJN is not like the office of managing director of First Bank or head of. It is cloaked in a lot of respect and awe. So when the CJN takes a decision on matters, a lot of times it is assumed that a lot of reasoning and mental work and education has gone in, and experience also has gone into the CJN's decision. So the decision does not, that's why you will not see the CJN coming out to say things anyhow. Because a lot of times, what the CJN says is taken to to look at as the position of the judiciary, which is not anyway, because each panel decides on its own what based on the facts given to it. But it tends to push what the decisions should tell the executive and the legislature how the mind of the judiciary is thinking about certain things. You understand? So that's why this particular act has been quite worrying. And like I said, this decision on the Justice of the Court of Appeal, the swearing in, has been quite worrying to a lot of people in the legal practice.
Yeah, but do you think those people have also given maybe full evaluation of the CJN's comment? Because you say lots of thoughts ordinarily should have gone into any comment that she makes. Do you think they've actually considered, because she will have documents and information before coming up with that decision, for instance?
We call my lord, not my lady. So we refer to her, my lord, as he all the time. That's on the side. But you see, like I said, corrections have been made. Moving forward, because it's not the first time, I've said it here, that a person had suffered, Justice Ige, had suffered the same thing before. You understand? It's not a fresh thing. So learning process, and the good thing about it is that it has become a national, because of this is going to the federal, the Court of Appeal, which is a national court. It has caused everybody to see the wrongness and of following the provisions of the Federal Character Act as relates to women. You understand? So now that we have found that, and I don't think it will ever happen again.
Yeah, but isn't this a precedent of sorts? Because even I did ask that, look, how do we correct that?
Well, she has reversed herself. So the current precedent now is that she has reversed herself.
So
the previous one, it cannot be binding. If she had insisted, I will not do it, and the woman is not sworn in, that's the precedent you have set.
Yeah, so does it then mean that the federal character principle is irrelevant in this case?
What it means in this particular, in the judiciary now, is that a judge, from wherever you are, whether married, you can be sworn in, you can be elevated from that place, you can be nominated from that place to whatever office.